It's not funded by the taxpayers. It comes from fees of licenses. You can see the application fees are very low. So we ended up with an enormous number of applications. Grower fees, $125,000 a year. Dispensary, $40,000. These numbers are kind of picked out of the air, so we're going to see how they work. I think initially they're probably going to be too small. We're going to see how that works. No fees from physicians to register. Physicians must register. No fees from patients. Patients must register. Identification card is not necessary to be a part of the system, but patients may want that for protection. Applying for a license, we're in this stage now where you apply for a pre-approval. The application deadline was in November, and we're now in the process where all of the applications are being reviewed, scored, and ranked by an independent third-party reviewer that we've hired. And then when we get their report, then the commission will consider those and will issue pre-approvals for licenses. Second stage then is upon the pre-approval, the applicant can complete financing, sign leases, buy property, do the construction, hiring, training. We're going to do our detailed financial background of those who have filed. We then inspect the premises, and if they pass, we award a license. They can start operating. So you can see we had over 1,000 applications, 146 grower applications for up to 15 grower licenses that we can issue, 124 processors, 811 dispensary applications. We're registering physicians. We had, as of last week, 117 physicians registered. Shaping the program, security and safety. We'll talk about this briefly. Chief of Police appointed by the Chief of Police Association, a state's attorney, represented the controller. So, limited number of growers, just 15. Growers can operate a dispensary. No other licensees can operate a dispensary, can operate more than a dispensary, to limit the availability and avoid concentration, 2 dispensaries in each of the 47 state senatorial districts. So that sets a maximum of 109. Everybody in the industry gets a fingerprint-based criminal history background check, no felony drug conviction, pre-employment urine testing, training, and a stated drug-free workplace policy. No one can get cannabis from somebody who's not a licensee. There's no home cultivation. The premises have to be very securely designed and equipped with security lighting, security alarms, 24/7 surveillance, and so forth. Local zoning and planning codes must be met. You don't get a license unless your facility meets the local planning and zoning codes. You have to control access. The control itself, we have seed to sale, diversion gets reported, very strict requirements, vaults, so forth. We're going to have regular inspection. We can fine violators. We can suspend violators. Any cannabis that's diverted is subject to much heightened prosecution. We have decriminalization. 10 grams or less is a $100 fine. If you have 10 grams of diverted cannabis, that can get you 5 years in prison and a $10,000 fine. In addition to what other CDS
How many grams did you say?
Our decriminalization law is 10 grams. So any quantity which is diverted triggers these felonies. So simple possession is up to a year. Possession of diverted cannabis is a felony up to 5 years. So we recognize we want, we want a system of a high degree of control and to try to prevent leakage. We're very aware that we can seek the assistance of the U.S. Department of Justice to investigate activities that are outside those permitted by regulation. We're very, very explicit about this. We drop hints that if we need the cooperation of the Department of Justice, we anticipate that the Department of Justice is probably going to be willing to prosecute people who are actually violating the Ogden-Cole memoranda. So in addition, patients don't get any kind of free ride. They can't operate vehicles. They can't smoke in vehicles. They can't smoke in public places. And every time they obtain the medication, they have to acknowledge that they understand those restrictions. The products are going to be, very carefully packaged. They can be child resistant if appropriate. Nothing to mislead someone about the contents. No cartoons, no fancy bright colors, no cartoon, nothing attractive to children. No resemblance to any trademark product. And we do not authorize edibles at this point. There's nothing in the statute that prohibits edibles, but under our state law, what would be edibles would be subject to the food laws. And the food production is very heavily regulated in our state. And so we wanted to make sure that, if there were edibles, that they followed the same kinds of rules that commercial food production required. And we weren't ready to get involved in that at this point. Setting up a medical cannabis approach is heavy enough burden to get started with. Packaging requires lot number, expiration date, contents, and so forth. Warnings. The packages all must carry these warnings. You can't transfer it to anyone. Poison control number has to be on the packaging. Phone number to report adverse patient events. So our goal is to produce medicine that is consistent, batch to batch, lot to lot. Law says, regulations say, we want a range of administrations. We want a range of different kinds of products. We want to be able to cover a lot of the different kinds of medical conditions that are involved. Specifically as well, there has to be high CBD levels as in some of the kinds of products that are made available. I will not see any of the applications until the scoring and reviewing process comes forward. We are very confident from the way in which we've set out our applications that our applicants know that if they do not spell out all of these kinds of things in their application, which they are going to be bound to. Their application is a contract with the commission if they get a license. So we're fairly confident that at least on the front end, we're going to get promises of an extraordinarily high degree of compliance with what we think would be a genuine medicine. This is the limit. They're going to tell us what they think the standards are, and if we don't like them, we reject the standards, they don't get a license. So their material has to meet the specifications. So they're in a great deal of competition to tell the people of Maryland that they're going to have a very high quality product. And if they haven't made those representations, they're not getting a license. These are the particular cannabinoids and terpenes that we want every batch and lot to be analyzed for. Does it mean, yes?
Well, I'm sorry, I'm being rude. Is this just for the potency or also the cleanliness of the product, right? Like
I'm going to get the cleanliness. These are the medicinal ingredients that we're looking for here. Prevention of contamination. Calls, record them, investigate them if they're serious. Physicians must register. You cannot issue a written certification in Maryland unless you register with the commission. There's no fee. It's valid for 2 years. The law does not require the regulations in the law do not require any specialized training. It must be a license that is active, unrestricted, and in good standing. There are physicians who practice medicine whose licenses are restricted and are not in good standing. They also have to be registered to do CDS prescribing in our state. They have to follow. They have to pledge at the time of registration that they're going to follow the highest kinds of standards of medical practice: inpatient evaluation, following patient outcome, follow-up care. Collect data, and they're going to check off conditions. I'll mention the conditions in a moment. They have to specify, they can establish other kinds of patient inclusion criteria. They can say, if they're a neurologist, my patients are only going to be neurological patients. So that they can exclude patients. They can say, I'm not going to treat anyone who is not subject to the nature of my particular specialty. We are trying to avoid the Venice Beach, California type of medical practice. The law says that the commission is encouraged to register those who will treat these chronic debilitating diseases and conditions. So, the wasting conditions, severe chronic pain, nausea, seizures, spasticity, and the commission added glaucoma and post-traumatic stress disorder. Here's an interesting feature of the Maryland law, and I've printed it verbatim. It may approve applications, this would be applications from physicians, that include any other condition that is severe, for which other medical treatments have been ineffective, if the symptoms reasonably can be expected to be relieved by the medical use of cannabis. And so what that reasonably can be expected to is obviously a very, very broad area that's not further defined in our regulations. And so that's going to be an area sort of to see how medical practice takes place here in our state. Patients must register with the commission. They must live in Maryland. If they are not otherwise Maryland, 3 minutes, if they're not otherwise Maryland residents, they have to be physically present for the purpose of receiving care. We do allow care of pediatric cases. There must be a bona fide relationship. This is all spelled out. It has to be a genuine relationship. The physician has to monitor. Physician logs onto our website to register, usual kinds of things. 30-day supply. The legislature told the commission to find 30-day supply, 120 grams of usable cannabis or 36 grams of delta-9 THC. Now that doesn't mean you use it every 30 days. We don't expect most patients will use it at that level. We also will allow greater quantity if there's a specific determination that's necessary. Patients can be terminated for a variety of circumstances, and the commission must be notified, and they're taken off the list of those who are registered. You can't renew until 30 days after a written certification. You cannot renew unless you've seen the patient in person within 365 days. Dispensaries, I mentioned the number. Dispensary agents must be trained extensively. Patient goes to the dispensary, gives proof of identity. Dispensary logs into the database to confirm that there is a written certification from a physician to determine how much cannabis can be dispensed. Now, the amount of cannabis that is dispensed is recorded by the commission. Every written certification is reported to the commission. So a patient goes in and gets 4 grams of this particular product, that's in our database. A week later, they go in and they get another 4 grams. A month after that, they get 10 grams of something. This can go on and collect, and if they do not need to renew their written certification until they have consumed 120 grams or 36 grams. So that's, we're not making it inconvenient for patients, we're trying to make it convenient for patients, but at the same time, in effect, they have an account that they can draw down on that is logged into the database. And because it's logged into the database, the physician knows on every instance, they can find out what their patient is getting, how much their patient is getting, exactly what it is in order to track what's going on. And so it's recorded in every instance. As I mentioned, the patient makes an acknowledgement on every occasion that they're taking the medication. They must acknowledge, of course, the illegality of transfer to others, various provisions regarding scientific research. We're all familiar with the federal role, the Treasury Memorandum of around banking, the acts of Congress regarding the bar of DEA from enforcement to interfere with state laws, the interpretation of that law that was just recently upheld. We have a FAQ page. We're eager to answer the questions of the public about how this program will work. This is a program that has not yet started. We do not know really how it's going to work. We know we're going to need a lot of compliance inspectors. We are trying to figure out how to anticipate what the ways in which criminals will attempt to exploit it. Will there be people who attempt to counterfeit material? Will there be people attempting to bring material in from other states? We believe that the value of these licenses are going to begin to create incentives for the licensed actors in the system to identify and help us suppress those who are attempting to subvert or take advantage of the system. That's that's essentially the heart of what we think is going to make this. This is not intended. This is an alarm.
And of course, he couldn't hit the cow because that would be violent. So when the cow figured this out, decided she could get away with anything. And one morning she kicked over the pail, and Quaker said to her friend, "Bossy, thee knows I may not beat thee, but I can sell thee to the Baptist down the road." So I think it's very important that the DEA be willing to play the Baptist down the road. And the way I read the Controlled Substances Act, the language telling the Attorney General to cooperate with state governments in enforcing the purpose of the act is mandatory language, not optional language. And I think it's time for somebody to tell the Justice Department that they better start doing their job under the law. And that's probably going to require some very high-level representations, because I think the Drug Enforcement Administration would love legalization to fail, and will do everything they can to help it fail. And I think that's going to need some pressure. So I think enforcement under quasi-legalization gets to be a very interesting problem. The other thing to say, and here I want to put most of the blame on the states rather than the federal government. Part of the promise that was made around now not medical marijuana, but about full adult legalization, was we were going to get rid of all that pesky drug law enforcement. And I think exactly the opposite ought to be the case. While cannabis is illegal and there's a mass market for it, enforcing the cannabis laws is one of the most useless things that any enforcement agency can do. Because every time you seize a grow, arrest a dealer, arrest a grower, seize a bundle, you're simply making room in the market for a substitute illicit product. And so the net benefit has got to be very close to zero. The moment there's a legal market, the value of enforcing against the residual illegal market
Goes way up.
has been transformed, goes way up. Because now what you're trying to do is port users from the illicit market to the licit market. The year after you legalize marijuana, you should have more marijuana arrests, not fewer. Because after legalization, the illegal market is a paper tiger. You can't possibly compete with a legal business using illegal means. Illegal stuff is always more expensive. But a paper tiger does not fall over until somebody pushes it. And so far, enforcement, neither in Washington nor in Colorado, has given the illicit market the push it needs.
So,
End of rant.
Pete, so that's probably a good place to bring in Pete to talk a little bit about the challenges from a state that really was not doing much enforcement, and particularly in your jurisdiction purposefully. And can you talk about our challenges now of trying to get enforcement?
Sure. Thanks, Sandy. I do want to make something clear at the outset. Sandy truly is from the state of Washington. I'm from the city of Seattle.
That's
so
very different.
Which seceded years ago.
That's right.
But we do cooperate a great deal, and you know, it's an important partnership. The partnership with the feds is a little bit more uncertain. But I did want to also drop another note that I was in Annapolis speaking to a lot of the legislators in Maryland about some of the things that they were doing, and I had urged them, I said, among other things, if we learned anything, if you can do adult use and medical at the same time, that's what you ought to do. This was the Friday before Seattle lost in the Super Bowl to the Patriots, and about the only thing that they were in agreement on is that they wanted Seattle to kick Patriot butt down. So anyway, we failed on that one as well. But in any event, in Seattle now, on July 1, we will have finally merged medical and recreational to get to the point at hand here. And we're already seeing, as a result just of the law being on the books, my office has been able to close fully half of the unlicensed medical dispensaries. Some of them have a pathway to citizenship under the law to where they might at least theoretically get a license. And so we've taken a very hands-off approach on those. A few others, the real die-hard holdouts, have asserted everything from federal preemption to Fifth Amendment reasons why state legalization is illegal, ironically. It was a real head-scratcher for the judges, by the way, and wait a minute, let me get to understand this. Because it's illegal at the federal level, you're saying it's wrong for the city to shut you down. Anyway, it was, we have, I think, wrested the rest of those creative legal theories out of the way. So now we're really left with actual enforcement. And, you know, it's amazing, the proof of order in the cosmos. I was actually late for the teleconference among all the speakers on this because I was, this was a week ago, I was on the phone with our county prosecutor, who is, in essence, what your state's attorney is. about a number, 7 or 8 delivery arrests that had just been made by the Seattle Police Department. Delivery is not legal under our system yet. I happen to support making it legal, but then, licensing it, regulating it, making sure that it complies with all of the other goals of state legalization. But right now, you're at best way out over your skis delivering, in fact, even advertising in newspapers and online that you have a delivery service. So I was quite pleased when our police department actually did a bust. We've seized a couple cars that would probably forfeit. But those are all felony distribution cases, like Mark was just saying, and the county prosecutor decided not to prosecute those, saying that there's something confusing about it. And the whole issue is, if you don't have a license, I thought it was just you that was
May I have your attention? May I have your attention? This is the fire safety.
say that of the half of the unlicensed dispensaries in the city of Seattle, we have about 130, fully half of them are gone now. Most of them, not one single arrest in any of the closures, not one single arrest. The litigation was handled by my office, the civil questions that were raised, and it's exactly an example of the force of good regulations comprehensively enforced. And then I'll close by saying, Mark is also absolutely right, that there has to be criminal enforcement to bolster the regulatory system. But this time we're not, as Sandy said at the beginning, we're not locking up largely black guys that have a joint in their pocket at a bus stop, right? We're going after people that are commercial operators, that are exploiting a demand in what they perceive to be a loosely enforced at best arena. And that's what we have to address at the regulatory side. And it takes state, federal, local cooperation, criminal, civil, and I think that we're on our way in Washington State is the end of it. I'm very excited about what we're doing, but it's a lot of just detail work. It's a lot of plumbing.
Josh, you want to talk about some of the work here in New York?
Sure. Thank you. And thank you for the invitation to speak. Really appreciate that these conversations are happening in New York. We're really excited about it and grateful to be a part of it. I just wanted to start by talking about what the Bureau of Narcotic Enforcement is, because it isn't what it sounds like. It's not a statewide agency that is working on eradicating drug trafficking, working against heroin, cocaine, etc. It's a small law enforcement agency within the New York State Department of Health, whose main mission is to prevent the diversion of controlled substances from institutional facilities like hospitals, nursing homes, that sort of thing. So our main focus before the medical marijuana program was housed within the Bureau was the diversion of opioids and was opioid prescribing. And that's certainly a major problem that we're dealing with in New York and elsewhere right now. But to talk about the medical marijuana program only, we really had to look at it within the context of the ideas that we were trying to embrace. And really the two bedrock principles of the Compassionate Care Act in New York were to provide for patient health and to protect public safety. And we wanted to do that within the context of the Cole Memorandum, which are you familiar with what the Cole Memorandum is? I know we sort of referred to it a couple times. Not just what the 8 law enforcement priorities were, but the statement from the Justice Department that federal law enforcement priorities would be elsewhere. They'd be rooted in other directions if we could show that we had a tightly regulated, strictly controlled system that was backed by vigorous and actual enforcement. So we set up our program to do just that. And it's part of the reason why things are set up the way they are in New York. Before the Compassionate Care Act could actually go into effect and patients could start receiving medical marijuana products back in January, the program had to be certified by both the Commissioner of Health and the Superintendent of State Police that the program could be implemented in a manner consistent with patient health and public safety standards. So with that in mind, we had a series of requirements that we make of the registered organizations in New York State. That is, those organizations that are permitted to grow and distribute medical marijuana products. They had to undergo vigorous background checks of their major officers and directors, as well as any management level person who was going to be handling marijuana. They have to have strict security features, both physical and related to personnel and visitors, for their dispensing facilities and their manufacturing site. They are completely responsible for the products that they handle from seed to sale. So there's one answering entity responsible for anything that may possibly go wrong, from the growth of the plant straight through to processing and distribution out to the manufacturing facilities. We have 5 registered organizations in New York State. Each one has a single manufacturing facility and 4 dispensing sites that are dispersed around the state. They're also subject to inspections by the Department of Health, and we have investigators who are part of our medical marijuana program who can go out and do announced or unannounced inspections at various times. Now, the Compassionate Care Act required that we have the program up and running within 18 months, which was a pretty tight framework to get things running. But I want to recognize the professional efforts of the registered organizations themselves, because by the time the selection process was over and they received their registrations, they only had 6 months to get up and going. And so they've been operating at just an absolutely high level of professionalism in getting their products together, making them available to patients, and opening on time. So we really want to commend them on that. We have tried to develop the best relationships that we can with them, because we're vested in seeing them succeed in a way that prevents the federal government from coming in and intervening in any way. So we have bi-weekly calls with them where we'll talk about various issues related to what they're allowed to do, what they're not. If they have questions, we can try and answer those as well. And we've integrated our medical marijuana program with our prescription drug monitoring program. And what that is a database that's maintained by the Bureau. The Bureau administers it. And it requires prescribers of controlled substances to review the data therein for their patients. And what they can see when they review the prescription drug monitoring program is the previous 6 months of their patient's controlled substance history. So physicians have to review this before they can certify a patient for the medical marijuana program. Pharmacies are required to report dispensing data of controlled substances back to the department within 24 hours of the dispensing occurring. So in integrating the medical marijuana program with that, what we're doing is we're making the same requirements of the registered organizations that dispense as well. They have to have a pharmacist on site at all times when the facility is open. That pharmacist has to check the PMP for the patient before dispensing the product, and they have to report their dispensed medical marijuana products back to us within the 24-hour period. So we're also working very closely with them to ensure that that data stays accurate within this PMP. With respect to physicians, who are the only ones who can certify patients right now, they are required to take a 4-hour course, which is available online. They can take it any time, day or night. It's $250 to take the course, and then upon completion of the course, they can register with the department and begin certifying patients. The certification itself has certain requirements within it to ensure that only people who are getting medical marijuana actually need it. So the physician has to certify that the patient that they're treating actually has one of the qualifying diseases and associated conditions, that they have talked about the benefits and the potential detriments of medical marijuana products, that in the view of the physician, someone is going to receive a palliative or a therapeutic benefit from medical marijuana. And there are a couple of other certifications that go along with that. But we're establishing that there is a doctor-patient relationship there, and the certification itself actually warns the physician that not only are false statements punishable as a Class A misdemeanor in New York State, but the fraudulent certification of a patient in the medical marijuana program is a Class E felony. So we'll talk a little bit more about that in just a second. But the requirement is designed basically to have these protections in place, and we can see, based on the data that we're getting in, on how many patients each doctor is certifying, where they're happening, and we get a sense of what diseases are being certified for the medical marijuana program. This, combined with the PDMP data, is going to be very valuable for us to see how the medical marijuana program is working in New York State. But by putting these things in place, we're hoping to cut down on the number of people who will try and game the system with the assistance of a physician, or as a physician, to obtain medical marijuana. With respect to patients, once they're certified for the program, they have to go and register with the department also. So they take their certification, they go online through ny.gov, which is an online site for the state of New York, which is available for a whole host of things for people to do business with the state. You can renew your driver's license registration, for example, through there. And they register with the department. Within a couple of days, the registration goes through and ID cards are printed and delivered to patients. And I say within a couple of days because there's a little bit of a time lag between their actual registration with the department and the printing and delivering of the card. But we're overnighting the ID cards to patients now in order to get those in their hands as quickly as possible. They can also designate caregivers who are permitted to be caregivers for up to 5 patients. Each patient can have up to 2 caregivers. And that entitles a caregiver to go to a dispensing facility and to purchase medical marijuana products on behalf of a patient who may not be able to travel or drive. So the system is set up in such a way that the New York State Police will be able to take those ID cards and review them in a traffic stop situation, for example, to see that a person actually is a legitimate caregiver or a legitimate patient and they're in lawful possession of the medical marijuana products. In addition to that, there is communication with the registered organizations that New York State is capable of policing this aspect of this program on its own, and we don't want to trigger federal intervention to come in. To date, we have 526 physicians registered with the program as of about this time last week, and 2,675 patients after about 90 days of operation. And as of yet, I'm not aware of any arrests under Penal Law Article 179 for any of those crimes related to the medical marijuana program itself. We had been asked about what this means, and you see it, I guess, sort of what we're learning from this larger view of things is that there's sort of an East Coast model of stricter regulation and tighter controls and a West Coast model of perhaps looser regulation and control, but greater access. And how is this affecting access? And one of the things that we wanted to do was ensure that anybody who had been certified for the program could get medical marijuana products. And taking it a step back before that, anybody who thought medical marijuana might be able to help them for their qualifying condition could find a doctor to certify them. In order to prevent diversion, and after speaking to doctors themselves, to prevent doctor shopping, to prevent what we were concerned might be creating targets out of doctors' offices in the mistaken belief that they may have medical marijuana products on hand or large amounts of cash at the end of the day due to the number of certifications that they were doing. We don't make a list of certifying doctors available online to the general public. And there's been some concern about whether or not that is something that should happen. But what we know is that we can also learn from the experience of other states. And we've seen so far with 23 other states that there's only one state that does that. And that state has fewer doctors registered after 3.5 years than we do in 90 days. And a full 25% of the doctors that they list online no longer accept patients. So the doctors warned us that it would have a chilling effect if we just published their names online. They didn't want their phone lines crashed. They didn't want their waiting rooms to be filled with non-medical users who were looking to obtain medical marijuana. But we tried to figure out what kind of a compromise we could reach. And what we learned was we have this tool at our disposal that we can make available, and we do. And it's called the Health Commerce System. And through that, it's a Department of Health site that's accessible to all physicians in New York State, as well as all nurse practitioners and licensed health professionals who treat the specified diseases. And they can go in through the HCS portal and see a full list of every doctor who has consented to be listed with the program. And they can make a referral to another doctor. So we're hopeful that this is going to be catching on and is going to gain some recognition, but we're doing as much as we can to put that out there as well. And what we're seeing is that a great number more doctors are agreeing to be listed on that HCS site behind the login of the professionals than would be online. So in our determination, we thought we could expand access much more by having that bigger list available to cover more of New York State.
So I want to, we'll take a break just a minute to quickly, I should have done this at the beginning, but just a quick show of hands, kind of who all you are, is folks from the industry, a few researchers, academics, policymakers. Okay, then another question, those of you from a state that has a current medical marijuana system. Okay, those of you from a state who are looking at medical or full legalization. So kind of current enforcement issues, see that in there. And did you hear something you want to respond to here? I thought you had some.
You're quite intuitive, Sandy. I did. There's a question for Josh, who raised the question about the chilling effect of public notification, public identification of the physicians.
Pass that down, you good?
I think everyone can hear me.
Nope.
Oh, this is being recorded, I'm sorry. Chilling effect of public identification of physicians. In Maryland, we were not going to have a public website of the physicians, but our public information law is very, very comprehensive and says that it's pretty clear that the identity of physicians who've obtained these licenses would be obtained, and a request is to be recognized by the state within 30 days. And so people who are interested in publicizing this information would be able to get the names of the physicians. And so we're facing a conundrum where we fear the chilling effect that you've identified, and yet the challenge of having to comply with our state public information law.
Yep. And I want to thank you for reminding me of that. New York has a personal privacy protection law, which means that the department cannot publicize the names of doctors who do not consent to be listed. So that was one barrier for us, and that exists, so we have to respect it. But it was in dealing with the remaining, and the question went out, we actually surveyed physicians and asked them, would you consent to be listed online to the general public? Would you consent to be on HCS through the system where the reach was more limited for a referral? And it was overwhelmingly in favor of being listed on HCS. So that was the decision that we had to make there.